This is Colin O'Keefe for LXBN TV and our affiliate Texas Bar TV. We are here again at the 2013 State Bar of Texas annual meeting. I am joined from Denton by Camille Milner. She just came out of a session discussing negotiation. I just gave an interview with David Bouchard on interest-based negotiation and how effective that can be. Can you tell me about the role interest-based negotiation plays in collaborative law and its effectiveness there?
Interest-based negotiation is basically the crux or foundation of collaborative law. Those are the techniques that we adhere to when we are doing negotiation in the collaborative law cases. In Texas, we were the first state in the country to have a collaborative law statute, and we have a new one as of 2011, which incorporates many of the new characteristics that have developed and evolved over the last nearly 15 years in collaborative practice. We look at what clients' interests are rather than their positions, and we help them learn to communicate and negotiate by empowering them and educating them so that they can develop a settlement between them that is good for their family and that enables them to have a continuing relationship. Now, we primarily use it in my practice in collaborative law, in family law, but it's also used in probate, guardianship, business deals, contracts, municipal or employment questions, anything where there might be a potential longer relationship that might be benefited by being protected.
Absolutely, and I've heard a lot more about collaborative law as of late, and I hear about it mostly what you talk about in family law, but have you seen it pick up? I mean, here in Texas, in other practice areas, what have you seen as far as the growth of interest-based negotiation and collaborative law?
We have seen it growing in other areas. Family law is still the main foothold because it has been existing in family law and flourishing there for so long because families so need a continuing relationship being protected and enhanced. But at our spring conference, the State Bar Collaborative Law Section Spring Conference, back in February of this year, there was a fellow that had been in a business relationship and the business was going to need to be dissolved, and he had a testimony where he talked about if it had not been for the use of collaborative law and negotiation techniques that were interest-based, the business probably would have gone under. And so by using these techniques, not only was he able to preserve the business, he eventually owned the business solely, but the man that had been his partner, the two of them were able to forge a new relationship and basically stay friends, when otherwise they probably, after litigation, would have been enemies and financially would have been much less advantaged.
Absolutely. As I just mentioned in the other interview, negotiation, especially interest-based negotiation, has numerous advantages over litigation. Once again, that was Camille Milner. For more of our coverage from the State Bar of Texas annual meeting, visit us at LXBN.com and TexasBarToday.com. Thank you, Camille.
Thank you, Colin.